Hello, this is Paul Johnson with The Optimistic American. I have a fascinating guest today. He's a law professor, James Phillips, who is the Constitutional Government Initiative Director at Wheatley at BYU. Now, James has a fascinating theory about how the Supreme Court and the role that they're playing is actually over-legislating. They've played such an active role that it's diminishing the role that our elected officials play in our society and our democracy. It's a fun discussion. I think that you'll like it. If you're interested in hearing, push that subscribe button and let's get going. Well, James, I'd like to welcome you onto the Optimistic American today and tell you how much we appreciate your being here.
Thanks for having me.
So I've already read through your resume and your accomplishments. I want to go right into this very unique position that you've taken from a legal standpoint and try to gain a better understanding of it. You called it juristocracy, but it's a view of what's happening with our Supreme Court and the politicization that seems to be happening there. Can you help me understand where you're coming from on that?
Yes, well, the Supreme Court has taken a role in our politics that it never was designed to take. Alexander Hamilton called it the least dangerous branch. He could have called it the weakest branch. He implicitly did so, saying it didn't have the powers of the other two branches. In fact, early Supreme Court justices didn't always love the job. They didn't always keep the job. They would leave the job when better government jobs came along. And yet that's hard to imagine today, right? They're celebrities and it is the apex of our legal system is how it's viewed. And something has gone wrong to do that. You can't, if you use something for that which it's not designed for, it doesn't work well. And that's what's going on with our court right now. It wasn't meant to decide all of the hot button issues. You'll notice in our Constitution that the first branch of government that's listed is Congress. Article 1 is Congress. And that's because the framers viewed that as the most powerful branch. That was the branch that was going to deal with these kinds of issues. And the Supreme Court's listed third. It is not supposed to act as a super legislature deciding these things that we can't decide ourselves. So there's a lot of reasons why that is, but it is not a healthy thing. And for our republic to kind of restore some of its health, because we do have some health issues right now as a republic. One of those things is going to be to not rely on the Supreme Court so much and to recognize that we probably should be relying a little bit more on Congress for some of the things that we've turned to the Supreme Court for.
So help me understand, maybe even give me an example, but help me understand how that plays out inside of our democracy.
So it plays out in this way. It is difficult to get legislation through Congress. It's designed to be difficult because the framers wanted only legislation to get through that had enough buy-in, right? And so you've got to get it through two different branches that kind of have different constituencies that they represent, and then you've got to get a president to not veto it. And so that's by design. Now it's gotten worse. Now it's even harder. And so if you can't get something through Congress, or even if you can, you recognize it's a lot of work, well, it's a lot easier to go file a lawsuit. And so instead of trying to get Congress to adopt new laws or amend laws that need changing, what's generally happening are folks are running to the courts and trying to get novel interpretations of existing law in order to essentially expand, right, laws or expand protections that they may want, or to get something done in our politics that it's just not happening through Congress. And people are rational. It is cheaper, probably, depending on if your attorneys are what your attorneys charge, or if they're representing you for free, which is often the case in this kind of public interest litigation. But it's cheaper. to go file that lawsuit and then appeal it up to the Supreme Court. And it's less work to try to convince 5 people at the U.S. Supreme Court that your, say, novel reading of a statute that now expands protections or that does this with the economy or whatever it is you want to do, right? Or you don't like what this president has done, so you want to try to get this regulation struck down. That's, convincing 5 is a lot different than convincing a majority in Congress. So this is not to say that courts don't play an important role. We saw the courts in the civil rights era do some important things, but the courts have continued to be happy, of course. When someone comes to their door, right, it's not like they're generally going to turn them away unless there's something called standing issues where they don't really have a dog in the fight, and courts, federal courts will not hear cases if it's just like, I don't like that law. It doesn't affect me, but I don't like it. They don't do that. But we've seen this before. Abraham Lincoln was worried about this. In his day, and leading up to his presidency, the issue was slavery. And could slavery expand? There were slave states and free states, and the U.S. was adding new new states, and there was always this debate, right? And what do we do with slavery? And the Supreme Court decided they wanted to end the debate on slavery. They're going to solve this contentious problem that Congress had been wrestling with for over half a century. One of the weaknesses with the original Constitution, and the Supreme Court said, we're going to decide this. We're going to end this debate, and they handed down, which is the most infamous decision in U.S. Supreme Court history, the Dred Scott case, right? And they specifically say in there, right, that they're trying to just, for once and for all, we're going to decide this issue. And Abraham Lincoln responded to that, and he said, look, if we let the Supreme Court decide these deeply contentious moral or political or economic important issues, then we've ceased to be our own rulers. I mean, this is supposed to be we the people. We're supposed to be the sovereign here, not the judges. And the organ through which the Constitution allows us to exercise our sovereignty most directly is through Congress, not the courts. So what happened with the Dred Scott case? Congress, people didn't try to run back to the court. They didn't try to pack the court and get on justices that would overturn it. Instead, Congress turns to the amendment process, and we get the 13th and 14th, and to a certain degree, 15th amendments in response to Dred Scott. So that is how our system is designed. That's where people get to kind of work those republic muscles, not when we just say, okay, court, decide it. But it's not just us. I mean, of course, we want to, it's not just the people, but our elected branches do this as well. So Congress used to care about whether what they were trying to pass was constitutional. And they considered that they had an independent duty, that they took an oath to the Constitution to only act in a constitutional way. So we see this early on, and feel free to interrupt me at any point with questions. But in, I think, 1796, there was this terrible fire in Savannah, Georgia, and wiped out much of the town. And Congress debates, well, do we send funds? And today people would be like, why would you even debate that? Well, of course you would, right? And yet at that time, they weren't sure that they had the constitutional authority under the spending clause to spend for something that wasn't for the general welfare of the nation. It was just to help this one community that was devastated. And they ended up not appropriating any funds because at the end of the day, a majority of Congress didn't feel like they had that constitutional authority. We don't see that today. And that ethos was with us more recently than 1796. So 1964 Civil Rights Act, right? Huge deal. And there was one senator on the floor who said, well, let's just pass it and we'll just let the Supreme Court decide whether it's constitutional. And several of his colleagues immediately said, no. That would be derogation of our duty. We have a duty to only pass stuff that we think is constitutional, that we're confident is constitutional. It's not we don't leave it up to the courts just to decide. But of course, fast forward to the last couple decades, and you see members of Congress saying, yeah, well, let's just pass it. The courts can decide whether it's constitutional. And we see this with presidents too, right? Presidents will sometimes issue signing statements where they say, well, I don't actually think this is constitutional, but I'll sign it, right? Probably for political reasons.
That's the new way with executive orders is you don't think that it's constitutional, and that's altogether great. Go ahead and pass it because you think the court will strike it down.
Yeah. Yeah. I mean, especially if there's some kind of cynical view that, well, I can get the political benefits of having this operate until a court strikes it down, or the political benefits of saying, well, I tried, but those bad courts struck it down. That's not how presidents used to be. Presidents used to veto only if they thought it was unconstitutional, not if they disagreed with it on policy grounds. And now we have often the reverse. And of course, you raised the point that we have, actions that presidents may know or may have pretty strong predilection is unconstitutional, but they want the political gain from it.
So help me understand, how do you implement this? Is this something that has to be implemented by constitutional amendment, by congressional action, or is this something that has to be done by the courts itself to the courts?
It's probably going to be an all hands on deck because it's not just the courts that are the problem. So no doubt the courts have played a role in the growth of their power and authority, but it's not just them. So Congress doesn't like to legislate anymore. They don't like to do the hard work of that. They would rather pass vague statutes and then just delegate authority to the administrative state or to the executive branch to figure out the difficulties and the details. And so when any of the branches is not operating relatively within its bounds and doing its job, and that could be it's going to affect the other branches. And often what we've seen is as Congress has shrunk, the courts and the president has grown. And so now we see a lot of effectively a legislation coming out of the executive branch through regulations instead of through Congress. And we see the courts being asked to do the work that Congress should be doing in updating laws for our modern life and modern sensibilities, or passing new laws, people running to the court. So I think part of it is trying to figure out how to get the branches to either stay within their bounds or to actually do their job. And that's going to require perhaps some institutional changes, maybe not at the constitutional level. There could be stuff that happens below that. So Yuval Levin has a great new book called American Covenant about the Constitution.
It is a good book.
And he has some suggestions for how to help try to get Congress to do their job. One of them is to reinvigorate the committees so that actually committees matter again and legislation actually matters again, perhaps. Another thing, he talked about, it's kind of interesting, is we may have too much transparency. There can be too much of a good thing. And if people in Congress can't get together, without cameras and without everybody knowing what they're saying to try to hash things out, then we're less likely to get them to try to do that, because people don't want to be seen as compromising or negotiating when they haven't gotten something yet.
Or stupid.
Yeah. So our Constitution was a product of this. In fact, James Madison once said years later that we wouldn't have had a Constitution if it wasn't for the rules of secrecy that we had in the deliberation. Now, the product wasn't secret, right? everybody could read what came out of it, just like everybody can read the things that come out of committees or the things that people vote on. But the deliberation, where people weren't going to be worried about changing their mind or having discussions and with the other side. So anyway, that's another suggestion that we've all lived in.
Yeah, I saw that in being mayor, and what's amazing is we got open meeting laws, and there's clearly some advantage to open meeting laws. But we also had the ability to have executive sessions where we could talk about lawsuits without having to go through that process. And what you find is that you'd find in these e-sessions, people would be very honest and direct about how they felt about some lawsuit or litigation that they would not have been had they had to do it in an open meeting. Because
Right.
they would have worried about, just as you said, their constituencies and who they might upset. But candidly, a lot of times people worry about the person out there with a cell phone that makes them look stupid, right? And because they're venturing into an area that they don't know all that well. I mean, we are a representative democracy, which means that you may have a school teacher who gets elected who knows nothing about street engineering. That's just the way it's going to work. Well, if you take that school teacher and you force them into talking in an open meeting, they probably won't. And if they don't, you're missing out on the ideas and the input that they may give. So I agree with you. I think that there are some areas where you want a transparent result, but where people ought to be able to have a conversation where they can say stupid things. And then somebody says, you might not want to say that because here's what that looks like, or here's what that means, which they're not going to do in an open meeting. It's going to be a full out war.
Right. Yeah. Another idea that he had or another concern he had was that our primary system has produced folks that only worry about winning primaries, and that's a constituency that they care about, and that tends to lead to very extreme positions, and it's hard to negotiate, to have principled accommodation with someone on the other side when everybody's coming from extreme positions. And so there may be some need to rethink our primary system and what we're doing there. Now, obviously, the people have a certain degree of power in this. My recollection in looking at primary participation rates are that they are somewhere around 10% of registered voters for that party.
That's right.
So
About 8 to 10%.
Yeah. So what you get are the most passionate, motivated folks who tend to perhaps also be the most extreme on their views, who are selecting the folks who win the primary. And a lot of House seats, for example, are pretty safe House seats through gerrymandering. And so that's the only election they generally have to worry about. So
Yeah, let me give you, to put that in perspective, out of 5,000 elected seats in the United States, 70% are decided in the primary. So you have, when you think about what that means in 70% of those seats, the representative never has to go meet with independents or people in the other party. So it's not just that they're not responsive to them. They don't know how to be responsive to them. They don't speak to them. They don't listen to them.
Right.
They don't hear their concerns.
Yeah, we tend to speak about rather than to people that are different from us these days.
Mm-hmm.
So, if 50, 60, 70, 80% of people registered in a party, and that's not all voters, right? Because, I think about a third of Americans are Republicans, about a third are Democrats, and a third are neither of those.
Yeah, close enough.
Yeah, I'm being very broad. But imagine if 60, 70, 80% of Democrats and 60, 70, 80% of Republicans showed up in the primary. We probably have different people winning those primaries. So, there's things that people can do. They can not vote for people, and they can actually, people that they think are just going to Congress to grandstand and to become a celebrity. But you got to get out and vote to do that, right? And I recognize that a lot of people are frustrated and feel like their vote doesn't matter, but that's kind of a bad cycle or spiral.
So I don't want to put a label on you, but I just want to have a better understanding of of where you're coming from. I know you spent time with the Federalist Society. Would you call yourself an originalist when it comes to constitutional law? Give me an understanding of the framework that you tend to see the law through.
So as far as interpreting the law, I see myself as an originalist or a textualist. Now, that's...
Explain what that means, too, because a lot of people won't understand.
So in a general sense, and then I'll get a little more nuanced. In a general sense, an originalist believes that the Constitution means what it meant when it was adopted, or if it's an amendment, when it was adopted, how it was understood at that time. And so the only way to change that meaning is through amendment. Judges can't change the meaning of the Constitution through interpretation, because we live in different times or we have different values. And so for me, original and textualism, it's just the kind of the same thing except for statutes. The statutes at the time they're enacted, what was their common understanding, or what was the meaning at the time, and that's the meaning they have until Congress decides to update them or refine them in some way. And the reason I'm originalist and a textualist is not because I necessarily agree with what the meaning or understanding was of the Constitution at a particular time. I mean, as far as my personal policy preferences, I might prefer something different, or a statute at a given time, but because I think that's the people's right exercised through their elected representatives to pass those laws and to change those laws when they don't think they work anymore. And
so help me understand this in context. I want to go to Gorsuch's new book. I don't know if you read Gorsuch's new book. I thought it was interesting. I think it's called Overruled. I think that's the name of the book. We'll put it up here on the screen so that you can see it. But one of the key points that he makes is based upon the Chevron decision, which I think was that 1968 or 1998? 84. There you go. I'm not even close. But in any event, this is my understanding. Please correct this as you go through it. I am not a lawyer and I'm not a constitutionalist. I'm deeply interested in the things that you have to say and in learning about it. But my understanding of the way that he saw it was that Chevron created this position that gave an advantage to the administrative state over an individual. So if an individual and the government showed up at a hearing and they were in conflict with one another, courts were supposed to advantage the governmental side as opposed to the individual. And in overturning that, he said what we were trying to say was, hey, the judge ought to see both of them as equal and ought to take the facts in the case and make a decision with it. But it seems to me that could reduce the power of the elected official. By the way, I like his thinking, and I think I agree with him. But on your issue, it seems to me that could, that by saying that you're not going to give the advantage to the government, you're kind of lowering the power of the elected official who passed that law. How do you see that? Put that in context with what you're talking about and help me understand it better.
Sure. So I would say it's a little bit different thing than originalism and textualism, although there's some connections. So what Chevron did, the Chevron doctrine, is it said that if an agency is implementing, or actually if an agency is interpreting a statute that it's been given authority over by Congress, and that statute is ambiguous, or that portion of the statute is ambiguous, then the courts will defer to the agency's interpretation of that statute as long as it's reasonable. And so what you have there, of course, is the agencies win a lot, right? Because there's kind of a broad spectrum of what's reasonable. And so they get to say, well, this is how we interpret it. And even if the court, so here's where it has bite, even if the court thinks that there is a better or more accurate reading of that statute, so long as the agencies was reasonable, the court defers. What this does is it delegates judicial power to interpret the law. And that is the judicial power, right? To interpret the law and apply it to disputes before courts. It delegates it to the agency. And an agency is not an elected branch. The president is elected, although not directly through popular vote necessarily. I mean, we have the Electoral College. The framers were very purposeful about that. But these agencies, they're not elected. The officials in them are not elected. They're appointed either by the president, the head of the agency, or by the agency head. Depends on the position. And so I think what Justice Gorsuch is saying is Chevron puts a thumb on the scale in favor of the government, and he probably also said in his book it outsources what the Constitution has asked courts to do to agencies. So it's a violation of the separation of powers. As far as how that ties into originalism or textualism is just how courts should be interpreting the law. Whereas Chevron is more of who should be doing the interpretation, right? Whether it should be the agency who's the expert in this area, or should it be the generalist court? And if folks would prefer that agencies interpreted the law because they're experts, we can have that happen, but it would require probably either amending the Administrative Procedures Act or probably amending Article 3 a little bit. But we can do that if we want to. The challenge, of course, is that agencies, they tend to exercise all three of the government powers. They are executing the law in that Congress passes some law, then they're interpreting and executing it. But they also make law through regulations, passing regulations underneath the statute, and then they adjudicate those. When you have a dispute, you often have to go to the agency first before you could go to a court. And Madison, drawing on a French political philosopher named Montesquieu, was fond of saying, look, when one, be it a person or a group, exercises all of the government powers, that's the very definition of tyranny. The whole point of the Constitution was to separate power because we don't trust it in any one person or any one group. So that's one of the concerns with agencies. But originalism and textualism is more to bind the judges, and so that they're not legislating from the bench is the phrase you sometimes hear.
But on the concept of juristocracy that you had spoken about, it almost seems like there has to be a pact of mutual destruction, meaning in a way, the courts, it seems to me, can actually be the group that's limiting the power of the administrative state and Congress. And if they reduce their powers too quickly, all of that could go to Congress, and Congress could dramatically increase it without having any real check. So I guess I'm trying to understand better, should the courts in their process actually start trying to say, look, it's not our job to be interpreting these laws and to begin to playing a lower role and forcing that back over to the elected officials? Or should they be playing the role of saying, no, you guys are trying to over administer, you're trying to over regulate? And I'll grant you, my belief is, I believe that the single most important thing that we can do is to ensure that you have maximum liberties for individuals. I believe the more liberty you have for individuals, the better off we do as a society. I think the greatest thing our government ever did was that it empowered the individual over itself. And I think the bigger government gets, the more they regulate, the more they spend, the less power the individual actually has to create and to innovate and to be able to create the types of products and innovations that we need to be able to make society work. I happen to see, I may be liberal on the pro-choice issue and I haven't agreed with the courts on that, but I kind of like what the courts have been doing on the business and regulatory end. I think they've been doing a good job. Some people may say they're over-legislating. How does that fit into the juristocracy issue? How would you see that concept? What is their role on that?
Well, again, courts have a role, right? And so courts can both be overactive and underactive at the same time on different things. So with Chevron is an example of courts being underactive, where they have delegated their judicial power to agencies and let agencies do things that perhaps they shouldn't have done. Whereas on other issues, the court may be overactive in trying to identify new rights or apply a statute to someone that it wasn't originally wouldn't have originally applied to, or what have you. So there isn't a one size fits all, I think, for the courts. Their job is to exercise their judicial power to their full extent and nothing more, and to not go beyond their judicial power. So with Chevron, they weren't exercising their judicial power to the full extent, but in other instances, they may be exercising legislative power to a certain degree because Congress won't act. So I think it depends on the issue, and I think it's a complicated thing. But that being said, we love to run to the courts, and that's a little bit of the juristocracy thing. We would much rather go file a lawsuit than go try to lobby Congress, and that's because it's easier in a way. But litigation is a zero-sum game most of the time. Courts are not institutionally designed to really kind of split the baby, so to speak. It's usually a winner-take-all scenario. And that may be appropriate in certain circumstances, but for our most important political issues, that is not a great recipe for legitimacy, for the country being less polarized and toxic, and having buy-in. Congress was designed to facilitate negotiation, compromise, getting through things with lots of different factions, James Madison called them, and having some buy-in with that. And so I think, I can't empirically prove it, but I kind of wonder if the fact that we have become a little bit more court-centric in our politics and trying to settle our things in the courts has not kind of started to affect Congress. And that Congress now sees, I mean, let's take the two main parties, kind of see things as zero-sum game, right? They either want everything or nothing. We'll wait till the next election if we can't get everything we want, because then we'll be able to ram something through when we have the power, and there isn't a lot of desire to reach across the aisle. Can we, what's most important to you? What's most important to me? What can we give up? What can we come up with something that's better than the status quo, even if we're not getting everything we want? And so I fear that our politics may be a little infected with the mindset institutionally.
I don't think there's any doubt. And what I like about what you're saying, I've always seen politics as you have these different factions, and there's a pressure cooker on both sides, right? And the pipes start getting full and compressed, and they're ready to blow, and then their side wins an election, and it lets that steam out, and then pressure begins to build on the other side. So the Dred Scott decision, I think, is a great example, because what happened was there was this thought of, hey, we're just going to fix the problem and take it off the table. Well, they didn't take anything off the table. All right, what they did is they just simply created a bigger problem by not having the elected body solve the problem. The same is true on the pro-choice issue. I mean, what I watched on pro-choice and pro-life, by the way, I happen to think both issues, both sides are in the fairway, meaning there's a fair argument on the pro-life side. I hear them and I understand where they're coming from, and I don't think they're bad people. I think they have a different point of view than me. My view is, well, at least from my standpoint, I had a baby at 17 years old, and my wife and I made the decision at the time to do that. And that meant I couldn't go to the school that I wanted to go to, and I had to go to night school to finish it. I always liked the idea, though, we made the choice. For me, that was important in the process. But what I saw in politics was that once one side got a decision, they began to think they didn't have to work anymore. They began to think that they didn't need to show up politically, that it wasn't important to them because the issue they cared about was taken care of. Not knowing, oh no, these things, that's not how it works. If you really care about this issue, you have to keep showing up. You have to keep talking. And if you keep talking long enough inside a legislative process, sooner or later you start to find common ground. You can actually start to find an area where you can get both the merits of both sides put out on the table and find a position that works. Now, that will never make the extremes happy,
right?
But you can get the overwhelming majority of Americans happy through that process.
And I think to the extent that we can do that process more, we will be healthier as a republic. And so, and that's the way the system is set up. It's set up. It's not supposed to be winner take all. That doesn't work in a pluralistic society. That doesn't work in a republic where the people are sovereign and the people are different and have different views and values. And so but courts aren't designed to work like that. They're not designed. They're not designed to kind of engage in mediation in a lawsuit, right? You can go to a mediator. That's a separate thing. But once you've gone to a court and filed a lawsuit, the judge's job is to figure out what the law says or means, figure out how that applies to the facts before that judge, and make the ruling. Thomas Jefferson considered, and he maybe had a bit of an extreme view, but he considered judges to be clerks. It's kind of a mechanical process. Now, the common law judges are a little bit different, but so yeah, we need to engage in that process, and that process is messy and it takes time. And we live in a society that doesn't like messy and doesn't like to wait. And so a court decision is cleaner and it doesn't take as much time, but it doesn't necessarily mean that is the best way to do this. It's interesting. Justice Ginsburg, of course, who was very much women's rights and in favor of abortion, criticized Roe as being she criticized the court for deciding Roe because the pro-choice movement was starting to have momentum in the states. We were starting to see states kind of adopt pro-choice laws, and she thought that would have been better in the long run and made actually her view, the pro-choice view, more stable and accepted. Instead, of course, what you saw in the wake of Roe was a culture war, right? And it didn't really change the kind of the pro-life versus pro-choice percentage in the American populace didn't change much from Roe to Dobbs. It was kind of entrenched, and she kind of argued that it probably wouldn't have been so entrenched if we had allowed it to happen more organically through the states or through a legislative process rather than kind of jammed down from the top from the court. Because once a court decides something is constitutional in our system, that's supreme. It ends debate. The only way to overturn a constitutional decision by the court is either to convince the court it was wrong and have it throw out the decision, and that's a hard thing to do, especially if you have the same justices, or to amend the Constitution. And so anytime the court is constitutionalizing something, it makes it hard. What can Congress do at that point? They could try to get an amendment sent out to the people. But so anyway, it's a fascinating thing that.
Yeah, I find the politics of that absolutely fascinating. And I find it fascinating because the right to lifers believed for the longest period of time, if you just return this to the states, it would end the discussion. The right to choose people believed as long as it stayed with the court, the decision was over. Well, of course, the right to choose people were definitely wrong because we've been fighting about this thing since Roe. It's a constant issue. What I've noticed is that now that it's back to the states, many, many people on the pro-life side have moderated. They've moderated because they know they can't win with the hardline issues that they had. So the hardline positions that were being taken in politics and inside of the primaries has now moved. Now maybe they're 10 weeks or 15 weeks. There's all different types of positions that are beginning to evolve on the right side of the ledger. But it is no longer a monolith of people who say it's pro-life from conception, and we don't want to have a discussion about anything else. In fact, the only thing that we want to argue about now is whether or not you should be able to have birth control. That debate has moved on the Republican side. And it's moved because they have to deal with this debate now in a real sense where they're talking at a local level about what it is that the people think as opposed to what it is that the evil court thought.
Yes, and this is another feature of our design, our constitutional design, is the federalism aspect of it, right? Where you empower people to have more involvement at the federal level or at the state level compared to the federal level, and they can get into these debates more. They can influence people more.
So let me ask you. I'm going to ask you one last question, and hopefully we can spend a little time on this. So there's a theory of mine, and it's it's a political theory that's applied into an area where I really don't know the politics nearly as well. So I'd love to just have your opinion on this. It seems to me that the politics of 20 years ago was that Democrats tended to want, or let's call it the liberal community, more activist type judges. And 20 years ago, the Republican side was looking more at the originalist thinking. They wanted to know what it was that the founders wanted when they passed the Constitution, or when the people passed an amendment, what it was that they were thinking. And so that became the debate. What's now happening is Vermeule, I think is his name, the professor at Harvard University who has a theory, and I think it's called common good constitutionalism, but it's very much a believer in activist judges. It's very much a believer in the idea of judges playing a more significant role and overruling our legislative body. It's just for a different set of policies. They want policies that are very, very right-wing, that would give them a greater ability to accomplish their social aims. Now, what's fascinating to me about that, as I told you a moment ago, I'm a believer in maximum liberty for individuals. Seems to me, I could be wrong, that's kind of originalist thinking also. I mean, originalist thinking might be, we need to be thinking about what the founders wanted, but they believed that most of the founders wanted maximum liberties for individuals. Is there a common ground between originalist thinking and the liberals now that you have these factions starting to appear, where maybe there could be more of a common ground between the two groups on public policy based upon that type of an idea? Or do you think that that's still far off and there's just going to be four fronts now instead of two?
I'm not sure. It does complicate things, right? So now you have kind of a bit of a split on the political right on the role of a judge. And should the judge, have a more narrow role in which whatever bargain Congress or the people in the Constitution have struck, the judge's job is just to figure that out and apply it? Or should the judge be bringing in their own values and what they think is right and just and good and best for society, and imposing them through the judicial power? I think you're right that, what I fear is that there may not be common ground between originalists and say, progressives on the role of a judge. If progressives are still, you had talked about 20 years ago, maybe they were more kind of use, I think, the term judicial activist thing. If they haven't left that, then basically what you have is two groups who view the role of the judge the same, but want different, or at least if you have the kind of the common good folks on the right, and at least some of the progressives on the left, who they want judges to do this kind of thing. They just disagree on the policy. I'm not sure. I'm not sure whether there could be common ground.
So let me play that out just for a second, so you think about that, because I think the left is every bit as divided as the right. The right now has, we know on the right with the MAGA movement, it's very MAGA movement, the isolationist, that group is very different from what I would call a Reagan Republican. Reagan Republican were people who wanted less government, who were looking for less government intervention. They wanted to get regulations out of our life. And they became to me, I could have this history wrong, they were where the originalists really began to gain their foothold through the Reagan era and the Reagan doctrine. Now, on the left, let's start with Kennedy instead of with Reagan. Right? It was a new type of thinking with civil rights, equal rights, human rights. That was a departure for the Democratic Party. That was not where the Democratic Party was before John F. Kennedy. And that began to evolve. Now, the change is this. I think Democrats wanted some guardrails, but they tended to believe in the maximum amount of liberties. That is not where progressives are. Progressives are in a very, very different place, right? They tend to believe, first, there's a fundamental belief, much like the alt-right, and I'm not going to say the MAGA right, because I think the MAGA right doesn't necessarily have to be as far right as the alt-right, the Proud Boys and the Oath Keepers and others, but the progressives, like the alt-right, tend to want to see people based upon the group they're in, as opposed to seeing them as an individual. They've abandoned the ideals of Martin Luther King, where we should judge people by the content of their character as opposed to the color of their skin. So everything is seen through this prism of there being this hierarchy of oppressors and hierarchy of victims. And so if you're in the wrong category, they want the same thing that the far right wants. They just want to turn the totem pole on its head. They want to see the minorities at the top, and they want to see white people who are they feel are guilty of white privilege as somehow being put back, right? So we end up having these battles like the university battle. I found that to be fascinating. The university said, hey, you shouldn't take away our ability to decide how many minority students we had. Okay, well, in a scarcity argument, that's maybe the right argument. But here's another one. Hey, how about you guys double the amount of enrollment you have and allow more people to get a degree online, and maybe you can have poor white kids and poor black kids both getting a Harvard degree, right? Maybe there could be an abundance of opportunity. But that is not how the progressives see things. They see everything from a scarcity mindset. My view is they're not far from the common good constitutionalist or the alt-right. To me, the liberal and the conservative, the old liberal and conservative, they have more in common with one another than they have in common with these two groups on each end.
Yeah, that strikes me. I mean, I'm not a political scientist, but that strikes me as probably true, that the Reagan Republicans and the Clinton Democrats are closer to each other than they are to the other elements in their party.
That's how I see it.
And then the question is, what's going to happen with that? Are they going to be able to overcome their differences and kind of work together to create a new power in American politics? Whether that's formally through some kind of party, we haven't had a new party since the 1850s, a new major party, or just figuring out how to work together, even if they still have an R and a D by their name. I don't know, but where we're at right now is not very healthy.
So I see Neil Gorsuch as that bridge. I'm not saying he's perfect in any stretch of the imagination, but when I listen to him, I go, wait a minute, this is a guy who's kind of talking a little bit about both things. He was a supporter of human rights, obviously, and what he passed in part of his legislation, and he's also a supporter of getting rid of the administrative state. Both of those things empower individuals. And I just look at that and think, hey, there's really a possibility from a legal standpoint that we begin to build a new coalition that's somewhere based around the center, which we would have never considered the center 20 years ago. We'd have considered them the extremes. But today, those two groups, I like the way you put it, the Clinton and Reagan factions are much closer than I was a Clinton person. I can tell you, I do not identify with the progressive movement at all. I think they're every bit as dangerous as the far right. I think they're talking about the same thing, about how do we divide this country up into pieces and argue about it from a scarcity standpoint. And everything I see says, why would we have a scarcity mindset in the United States of America? This is the one place you should have an abundance mindset.
We are a very prosperous, blessed nation. Maybe we can do a bit better job of spreading it around, but I think we have enough for everybody.
So I like the way that you put that on Vermeule's theory with the common good constitutionalists. How big of a movement is that really in the right-wing legal circles? Is that just a fringe in your mind, or is it something that's actually growing?
I think it's still a little unclear. I think it comes from a place where conservatives or the right feel like originalism failed them, that they're not getting the substantive victories that they want. They're not getting the outcomes that they want. And so they want to shift to more of an outcome-based approach. I think it's uncertain yet whether this is going to become the dominant movement within the conservative or right, political right, or whether it's going to peter out. But it seems to be a little bit generational. And so I think younger folks are a little bit more attracted to the common good constitutionalism. And the older generation are a little bit more like, what are you doing? This is the very reason we have originalism. You're doing the very thing that we were against. Like, how can you do this? So generational our demographics, can affect how a movement succeeds or not. And we'll just have to see whether it has staying power. It could. And I don't, from my perspective, I don't think that would be a good thing, because I don't think that's the proper role of a judge. And that, again, weakens Congress's role. We need Congress to be doing this rather than the judges. But I think there's some tension now. And I don't know if we know yet how that's all going to play out.
Fascinating. All right. Well, thank you very much for coming on our show. I feel a lot smarter today than I felt right before our show. And thank you for all the good work that you're doing.
Thanks for having me.
So if somebody wanted to look you up, and do you have a website or anything else that they may be able to go to?
So I'm at the Wheatley Institute at Brigham Young University. So if you just, did a search on the internet for that, and then I'm the director of the Constitutional Government Initiative. So, under the Who We Are tab or whatever, I'll be listed. So.
All right. Thanks a lot, Professor. We appreciate your being here today.
Thank you.
Thanks for joining the Optimistic American Show. Now, help us grow by subscribing to our channel. If you enjoyed the episode, please leave a like and a comment. There is so much more that we have planned. We can't wait for you to embark upon this journey with us.